Welcome to the AABANY Legal Writing Panel. My name is Thomas Lee. I'm the Leitner Family Professor of Law at Fordham Law School, and we have an extremely distinguished panel to present to you today. It's my pleasure to introduce Judge Denny Chin, Senior Judge of the U.S. Court of Appeals for the Second Circuit, Joon Kim, partner at Cleary Gottlieb and former acting attorney for the Southern District of New York, and Sapna Palla, who is a former president of AABANY and currently a partner at Allen and Overy. And so what we're going to talk about is legal writing, which I think it's no exaggeration to say is probably the most important thing young lawyers should be able to do, to be good at their craft and to make a good impression and to be helpful to everyone that they work with. And so without further ado, I'm just going to moderate, have some observations, but Judge Chin and all of you will have received, if you haven't already, a writing packet that he has prepared. He's extremely qualified for this, not only because he's been a judge, but because for many, many years, he's been a legal writing instructor at Fordham Law School, of which he's a proud alum. So without further ado, Judge, take it away.
Thank you. I'm going to talk just for 10 minutes or so, just to give a bit of an overview. I taught legal writing to first-year students at Fordham for more than 30 years. I'm not doing it any longer. This semester, I'm actually teaching appellate advocacy and civil rights. Next semester, Professor Lee and I will once again teach our seminar on Asian Americans and the law. So I am trying to do more teaching this year, a little bit different from what I had done over the years. But over the years, I've done a writing program many times, including with Gottlieb. The Federal Bar Council has an appellate advocacy program that I've done for many years. Even for the CJA panel, in both the Eastern and the Southern districts, they have CJA mentoring programs where they're trying to, among other things, diversify their panels of CJA lawyers. And I do a writing program for both those programs. I'm going to do the Eastern District next month. It's obviously hard to talk about writing in 10 minutes, and then we're going to turn it over to my colleagues here and let them add things. And so I'm going to do the best I can with just a little bit of an overview. You know, I agree with Professor Lee that writing is perhaps a young lawyer's most important tool or skill. But it's not just the young lawyer, it's the more senior lawyers as well. Although in addition to the writing skills, we have to pick up editing skills. Editing is just as important as writing. And for judges, you know, I have 4 law clerks, several interns. They do a lot of writing, and I do a lot of editing. And you know, there's the internal writing, which is analysis, some persuasion, the internal office memos, the bench memos that my law clerks do for me. There's the external writing, the persuasive writing, the hopefully persuasive writing, the obviously memos of law to the court, briefs to the appellate court. You know, but in other contexts as well. I mean, I'm most familiar with writing in terms of litigators, but transactional lawyers do a fair amount of writing. Whatever area you're in, you'll do research memos, office memos for your clients. So you were sent an outline, a handout. The handout has the outline that I've been using, and there are also some attachments to it, things I picked up over the years which I think are still helpful. Some of them are somewhat dated, but I think they're still helpful. When I think of writing, there are three areas I think about. First, mastering the basics. If you're a young lawyer in particular, you want to make sure you're writing grammatical sentences, your writing is clear. Strunk and white is still a very important aid. It's something that we should all reread from time to time. Mastering the basics. Another area is organization. Organization is so important. If your brief is well organized, it will write itself. And you want it to move from one area to the next, you're making things easy for the reader. And a lot of that is dependent on how well organized it is. And I'll come back to this in a moment. Your boxes of thought that lead from one thought to the next, And then finally, you want to raise the level of your writing. You've mastered the basics. You want to now get to the point where it's elegant, powerful writing.
Do you want me to put this on?
That really does the job. In the handout, there are some exhibits. Exhibit A is a opinion of the Ninth Circuit from many years ago, filed in 1977, called the Gottlieb case. And if you look at the second page, in footnote, actually look at the head note back on the first page, head note 3, key number 712, federal court 712. Briefs should be written in the English language. That is the head note. And if you go to the footnote 2 on page 2, the court quotes the sentence that caused it to write this, to write that brief should be written in the English language. The sentence says, the duty owing from defendants to plaintiffs in the abstract will vary under White relative to the juxtaposition of the real world, environmental encasement of the two sides. The concept of causation would seem less plastic. And you read those sentences and you say, what do those sentences say? You have no idea what they are saying. They are not written in the English language. They are flabby. They're trying to use all these big words. It's imprecise. Who knows? If I'm reading a brief and I see that sentence, it stops me cold. I don't know what the writer is trying to say. It's certainly not going to persuade me. And you don't want those kinds of sentences in your writings, whether they're to the Ninth Circuit or whether maybe worse to your client. Your client is certainly not going to understand it. And if your goal is to persuade, those kinds of sentences will not persuade. What are the keys to good legal writing? For the young lawyers, when I interview for law clerks, I usually ask the applicant a question. The question is, if you could pick one word to describe the key to good legal writing, what would your one word be? And, they hesitate for a moment, and then you hear lots of different words. My word is clarity. To me, clarity is the key. Clarity will pick up a lot of the other things. I mean, clarity will pick up organization. It'll pick up conciseness. I like clarity. And a big part of it is you want to eliminate your fuzzy ideas, your fuzzy thoughts, or you might have an approximate idea. What do I mean by an approximate idea? Well, you have a general idea of what you're trying to say, but you need to sharpen it up. If you have a fuzzy thought and you put it into a sentence, you're going to wind up with a fuzzy sentence. So think about it, sharpen it up. I'm a big believer in thinking before you write. Some people have different styles. They use the writing process to help them clarify their thinking. For me, it's much better to clarify your thinking and then put it in writing. I used to run every day. I've had 2 back surgeries. I don't run anymore. But when I ran, I would actually write while I was running. And by that, I mean, I would be thinking about something, coming up with some wording. I would run to the courthouse, arrive in chambers, turn on my computer, first thing I would do, and then type out the sentence. And having thought about it, hopefully it came out clearer. And with clarity, also, you are getting to the heart of it. You are distilling things to the essence. And hopefully that will help you with the clarity. A second important point is rhythm. Rhythm in your writing. And what do I mean by rhythm? Well, good writing moves like good music moves. You're reading something, you're just propelled along. You don't stop. You understand exactly what the writer is saying. You aren't brought to a halt by an awkward sentence. You aren't stopped because you see a bad typo, which throws you off. You aren't stopped because you don't understand what is being said. And it moves, it sings. How do you make your writing move? Clarity, think before you write, good organization, the chains of logic. You want to have roadmaps and road signs for the reader. You want to tell the reader where you are going. It's very useful when you begin your argument section to have a roadmap sentence, which lays out where you're going, and then you follow it. In one of the exhibits, there are samples of setting up the boxes of thought. You want to add a conclusion, or actually an opening. You are now entering the village of element 3. And then when you do your discussion, and as you are leaving, you are now leaving the village of element 3. You want to make things easy for your reader. The roadmap paragraphs and roadmap sentences, I think, are very important. You want to spell out your reasoning. It's very important for us as the court to understand how you got there, not just what your conclusion is, but what is your reasoning. Another important area is collision. Collision. What do I mean by collision? I mean taking on the other side's strong points and addressing them, hopefully overcoming them. If you don't overcome the other side's strong points, you're less likely to win. You're not going to win by ignoring the other side's strong points. Collision is important. Also, hand in hand with that is acknowledging your weaknesses. Be ready to be probed on your weaknesses. When you are up there in oral argument and I am questioning you, not surprisingly, I'm asking you things based on the other side's strong points. And I'm looking to hear your answers and how you respond with respect to the strong points. Another point, compression. Conciseness, no unnecessary words, like in Strunk and White, there's the example, machine should have no unnecessary parts. A paragraph should have no unnecessary sentences. A sentence should have no unnecessary words. You don't want to do throat clearing phrases. For example, we had an argument the other day, last week. Defense counsel said 6 times, "It is our position that." 4 or 5 times he said, "I think that, I believe that." It is my position that the sky is blue. Even worse, it is my position that the defendant is not guilty. That's your position that he's not guilty? You should be much firmer. The defendant is not guilty. Candor is important. You can't lie to the court. Active voice. I've talked about organization already. When I do organization, I like to go this way. What's the issue? Why I am right? Why I come to this conclusion? Why the other side is wrong, or why the losing side is wrong? Sometimes lawyers start with that and it becomes defensive. And you want to have a suitable design, like Strunk and White says. And usually the best design is the simplest one. Point headings, table of contents are important. I often will start simply by looking at the table of contents. That helps with the organization. You don't want your point headings to be too long. Summary of the argument. I'm going to finish up in another minute. The summary of the argument is probably the most important part of the brief. The big picture, you want to give your theory of the case, the crux of the case. You ought to be able to explain your case in 2 sentences. And if you do it right, then someone, the person who's listening, who knows nothing about the case, is sympathetic. When I am sorting things out and writing my opinion, I often go back and revisit the summary of the argument. Appearance, blue book, typos, I'll simply say, these are important. You want it to look professional. You're not going to lose because you're not following the blue book, but on the other hand, it's a loss of credibility. And finally, hard work. The key is hard work. When I was in law school, I'd stay up late, write something, send it in, first draft, and I did okay. And over the years, I've come to realize how important it is to self-edit, to go back over. First, I like to think of white space editing. And by that, I mean the structure, organization. And then after I've gotten it organized the way I want, the line by line editing and getting it to the point where I want it, where every sentence reads well. And then you turn it over to someone else to take another look at it. I'll stop there.
Thank you, Judge. Sapna, we'll move on to you. And so you sort of have a different perspective because you specialize in intellectual property and you're in private practice. So I'm just wondering, particularly for the younger, our associates and law students, what words of wisdom you might share as well.
Yeah, no, thank you. And thanks, Judge Chin. I think I learned a couple of things along the way in your first 10 minutes of presentation. So thank you for that. As Professor Lee said, my background is intellectual property. I'm a litigator in the intellectual property space, focusing particularly on life sciences. So when you think about protecting patents in the patent space, whether it is in the pharma side or medical devices, biotech, I basically defend those patents. And I also work with clients in thinking about strategy through the product life cycle of their products, of their patent portfolios. I'm very excited to be here, and thank you all for joining. And I'm going to give my perspective. I think I'll start out with advice that I have for law students as well as young lawyers in terms of what are the tools that they can use as they develop their legal writing styles. And then I'll move on to what I consider are some of the do's and don'ts of legal writing from my perspective, and some of it echoes what Judge Chin just expressed. And, hopefully when I'm before a judge, I'm doing some of the right things that he was talking about. And then I will end it with some specific examples. If you happen to be in a space like mine where the technology is pretty complicated, right? And you still have to argue and make your case and present your positions, some hints and tips on how you can do that. So let me get started. So first I'll say is that legal writing and developing your style is a process that takes a while. So you shouldn't be nervous as you start out your careers that it is sometimes one of the most daunting things. It certainly was for me. So even though you might have the training, even though you might, think that you have done a decent job while you are in law school, when you move into practice, it's that fear of saying, okay, this is a piece of writing that is going to be judged by people that I work for or by my clients. And that is something that's always, at least for me, was daunting. So for those who are and who find that process to be daunting, don't be, because the key to this is that the more you do of it, the better you're going to get at it. So that's my first sort of piece of advice is you really, it's like anything that you're learning, keep doing it and you're going to get better. As a law student, most of you or some of you, I think there's a mixture here, but the first step is attending seminars like this. You're taking the step in the right direction, hearing from practitioners in the field, that really gives you a perspective, and it's a great way of learning. Moot court, advocacy classes, opportunities for writing in clinics. I, for example, when I was in law school, was part of an arbitration clinic, and that really helped me to understand what it is to write in a legal fashion and what works and what doesn't. Pro bono work, if you can get access to that early on, you can start developing your writing style. As a junior associate, to the extent your firm has the resources and are providing writing programs, that's a great way to get involved. But equally importantly is getting feedback. So whether you're a law student or whether you are a young practicing attorney, seek the feedback, because unless somebody else puts eyes on your piece of work, it's just very hard for you to get an understanding of what am I doing the right thing or not. So don't be afraid of feedback. Go out and get it, whether it is from people who are more senior than you, whether it's professors in your school, or whether it's just other friends that who happen to be in the field and would spend a little bit of time in looking at your writing, because I think feedback is immensely important. As Judge Chin mentioned, for me, the outline is, the place to start. So so for example, I'll just give an example. Say I'm involved in a case, right? And there are many facts coming at you. There are many arguments that you want to make. You want to strategize in certain ways. There's a lot of information that you're dealing with. You have to have a roadmap before you start a piece of legal writing, whether it is a brief that you're writing, whether it is an internal memo that you need to present, whether it is a law review article that you're going to be working on, whether it's a letter that you're sending to opposing counsel. Get into the habit of sitting down and just thinking about what it is that you want to do. I don't run, so that's not the time when I do my thinking, but I certainly believe, and I'm more of a person who puts pen to paper. So but I need that outline before I start. And I could not agree more that you need that level of clarity in order to be able to have the roadmap so that you know where you're going next, because that is just going to make your job immensely easier. And I know it's hard to sit down and outline because you feel, well, maybe I'm not capturing everything that I need to capture in my outline. That's okay. Go ahead, do it. And as you go through the process and as you're reading more documents, you can always supplement what you need to supplement. But it is immensely important and helpful to have that initial outline that you need to do. Think about the theme. So whether, even if it's just a simple sort of letter that you're writing to the other side, or whether it is, an internal memo, what is the theme of your case? What is it that you're trying to present? Who is your audience? It's really important to think about that because, not all of us in terms of legal writing are going to be litigators, for example. We could be doing we could have other practices in the law where we're not writing briefs, right? But there is some level of legal writing that's involved in everything that you're doing, even if you're, a corporate attorney and are working on these agreements. And I, can't profess to know any of that because I've never done that. But I would imagine that even there, you need to be presenting to your client, to others, your legal clarity, your legal thought. So it's really important to know who your audience is. For litigators, it's really important to know the theme, because every time you are presenting your case, even if it's the most, dry facts ever, even if you think, it's a case, sometimes, technologies that I'm dealing with, some folks might view that as, really dry, like, there's no exciting story there, is there? I mean, you have a patent, you're defending it. No, there is a story in every case that you present. And even if you don't think there is, you have to find it, because unless you do that, it's not going to be as effective. And I let Judge Chin comment on that. If he looks for the theme and for the story in order for any argument that's made in front of him to resonate. So I'll just give one example in the importance of coming to a theme. So, for example, you are presenting a client saying that this is a person who is a pillar of the community, right? That person then walks into a bar and spills beer on someone, right? So what is the sort of the story that you're creating behind this? Here's a person who is a pillar of the community. If they spill a beer, people are going to look at that as, okay, maybe that was a mistake, right? On the other hand, if you want to present this person as something else and you're building the theme, you're building your story, you talk about the fact that this person is very dishonest, they're committed all sorts of things. They walk into a bar and spill beer on someone, right? What's the impression going to be? The impression is going to be is that this was not accidental, right? This is a person who has a certain character, who has done certain, undesirable things, and therefore they must have purposely spilled that beer. So once you have the facts and the arguments and the themes decided and properly laid out, your arguments will follow. Make your points up front, right? I think, whether it is as a litigator, that is immensely important, but also other pieces of legal writing, you have to have clarity in putting out your point, right? What is the point? What are you trying to say? I usually like to have 4 points that I follow and that I like to sort of bring up front before I do any piece of writing, which is, what is the issue? Is there any legal law or precedent that I'm relying on? What is that? What is my reasoning to support my issue? And what is my conclusion, right? So if you can sort of distill that and come up with that, that is going to really help you in terms of being persuasive and in terms of presenting your thoughts more clearly. I think Judge Chin mentioned, and this is for folks who are either in litigation or want to go into litigation, and I write a lot of briefs and look at a lot of briefs. The headings, I think, are so important, and sometimes people waste that as an opportunity. If you can, as part of your roadmap, have headings that are really pertinent, as well as headings that can sway the reader to your side, use those as often as you can. Shorter sentences and shorter paragraphs. I think, especially as a junior attorney, I wanted to impress people. I wanted to write sentences with, that were long, that were complicated, that I thought were very well structured and put together with a lot of thought in it, using big words. I realized over the years that that is not something that is the most effective way of getting your thought across, right? And so now I try to keep my sentences shorter. I actually sometimes count the words, right? So I try to go by the rule of 10 to 15 words a sentence. 10 to 12 is better than 15. And if you can manage that, try to do that. Paragraphs, keep them short, right? I try to go by 7 to 8 sentences to a paragraph, depending on the circumstances, obviously. But just tips like that are helpful in order to make sure that you are getting your point across. I don't want to go over time, but I just want to add a couple more points. So edit, edit, edit. Immensely important. Take your work, put it aside, come back, look at it again. Digital sources. I know all of you are much more savvy than me, certainly, in terms of using the technology that's available. But there is a lot of technology available nowadays in order to be able to put your writing through that and make sure that you come out with a polished piece, right? And use that technology, which I'm sure all of you are very facile with, and use that to help your writing, to give you feedback, as well as put out a more polished piece. I'm going to finally end with my area of work and writing about tech. As you know, that can get complicated. It can bore the reader, including judges. And I'm sure Judge Chin has had to deal with a number of highly technical patent cases that were not as interesting or perhaps too dense in terms of the technology. So what I try to do is provide examples, right? So you're dealing with, complicated, for example, a cancer drug, the different mechanisms of action, what happens in the body and why your patent was not disclosed earlier. To the extent you can do illustrations, to the extent you can do visuals, to the extent you can provide sort of real life examples or analogies, do that as much as possible. And I think that doesn't apply just to the patent space. I think in your writing, if you can do that, that will really help the reader understand the points that you're trying to make. So I'll stop with that. Hopefully folks found that helpful, and we're happy to take questions after towards the end of the session. So thank you.
Thank you, Sapna. And I know that the judge has used graphics in some of his opinions, and that you sort of would agree with that point about sometimes using representations to get the point across is probably a good thing to do, particularly when you're dealing with complicated things like patents. Joon, do you want to share some of your thoughts, both as a private practice lawyer and a longtime prosecutor, and in charge of an office with a lot of young prosecutors and in a supervisory role with respect to their writing, among other things?
Sure. Thanks. And first, I'll join in saying that it's a real pleasure and privilege to be on this panel with Judge Chin and Sapna and you, Tom, just real experts. And so, Tom, by you putting me last, you've assured that anything I might say has already been said. Certainly, and in the materials that Judge Chin circulated, I was reading that, it wasn't clear what you wanted us to talk about. Beyond that, that's new. So what I'll do is really reinforce the points that I find most compelling. They've all already been said, and they're certainly in the materials, which really I thought were excellent. I'll start with the elements of style in Strunk and White. Judge Chin talked about it. It is an incredible resource, and most people, I'm sure, know about it and had it in college or high school. It really has all the rules there to write in the way that we've been talking about, clearly and well and concisely. I actually was going to use it as a demonstrative exhibit because I have it here, but then I realized with remote working, I'd taken it home. So I don't have it, but I literally have it here. And we'll look at it.
By the way, there's an illustrated version that someone gave me. You can get a Strunk and White with drawings in it. It's quite nice.
It's a great resource, and it's well written, not surprisingly. So it's actually an interesting read as well. So, go to that. And a lot of what I would say, and I think has been said, is in the elements of style, but use the active voice. I think that's incredibly important. I actually am surprised at how much writing we get from junior associates and where it's not active. There's just a lot of passive voice, and you just using active voice will actually get you past some of the other advice that we've been hearing about being concise and being persuasive. And when I write or edit, literally going through every sentence and asking the question, is this an inactive voice? And if it's not, converting it to active voice, unless there's a reason for it to be in passive voice. And on rare occasions, you leave something in passive voice because you're actually maybe deliberately trying to make it seem a little obscure, or you don't want clarity on that point. Absent a reason for passive voice, you should try to convert it, every sentence, to active voice. Similarly, be concise. An active voice is more concise. And as Judge Chin and others have said, good writing is concise. But it takes a lot of work. It actually, the first draft of what you write won't be as concise as it can or needs to be. And so you go back and you write it and you look through every sentence and say, is every word here necessary? Is every word the best word you can use for this, the point you're trying to get across. And if it's not, you change it. There's the saying that I think is attributed to many different people, but most frequently to Mark Twain, who said something like, I didn't have time to write you a short letter, so here's a long one, because it takes work to make it shorter and to make it concise. But that's something, your second, third draft should be shorter than your first, not the other way around. Use plain English. People have said that again. Avoid Latin terms. Unless there's no other way to convey that thought, use plain English and use smaller words. For some of us, that's easier because we don't know that many big words. But some of you do. You know a lot of big words and you want to show that you know them. But they generally speaking don't help. They make it more difficult to understand. And the point of writing, particularly legal writing, is to persuade. And the only way you persuade is by explaining clearly your point. And I think using plain English is the best way to do it. Organize your writing. We've gone through that. We've talked about having a logical flow. You should build to a conclusion. You should take every step. You shouldn't skip steps. And generally speaking, when you're writing something in our profession, you know a lot about it already. You've been working on a matter for weeks, months, years, and you just sort of assume certain things because it's sort of second nature to you. In any legal writing, any brief you write, someone off the street should be able to pick up and read and understand your point and think you're right. And so you have to make sure that you're not skipping steps just because you know it too well and you think it's obvious. Make sure it flows logically and you're not skipping steps. Signposts, the reader, they're not always going to read it from beginning to end in one sitting, particularly long documents, and busy people like judges. And you need them to know, the reader needs to know at any point in legal writing in a brief, where you were, where you are there, and where you're heading. It shouldn't be hard. You have to make it easy for the reader and for a reader with very little to no prior knowledge of the case. Another point, I think, in legal writing to remember, particularly I see this in some of the more junior lawyers who are used to sort of law review writing, is to remember that the purpose is to advocate. It's to convince the reader. The purpose is not to show how much work you've done or how many cases you've read or just sort of proving that you did the work or that you're thorough. Obviously, it's important to read all the cases, be thorough if it's persuasive, and sort of making sure your writing is geared towards achieving that purpose of advocacy. That doesn't mean, that's not the same thing as being over the top or aggressive. In fact, sometimes it means toning it down. Advocacy takes different forms depending on what the argument is, where you are in your writing. The statement of facts is, people say, you should be laying out the facts, but there's a way to lay out the facts in a way that leads the reader to your position without being obvious. And that takes work and that takes skill, but it takes remembering that the purpose of that part of the brief is not simply to lay out all the facts and every piece of information. It's to lay it out in a way that persuades. Similar point that I think others have mentioned is the importance of maintaining credibility. In written, oral, or any form of advocacy, the argument is only as persuasive as the messenger. And if you lose credibility, then your arguments are going to lose credibility. And even in written advocacy, you have to think about making sure you maintain credibility. How do you do that? It's, as the judge said, confronting your weak points. It's not ignoring them. If you know there's a bad fact that is obvious, you need to confront and address it, not ignore it. If you have helpful facts, you need to present it clearly. You can't overstate it. You have to maintain your credibility in writing as you would in oral advocacy. I think people know, right? If you're arguing before court, you have to maintain your credibility. The same thing goes for written advocacy and written word product. And that goes to the point of making sure there aren't errors, like reading it over again, making sure that there aren't missing words or typos or things like that that undermine the overall reliability of the messenger, which is you. On cases, and this would be specific to sort of litigation writing, remember the facts are important. A lot of times you'll get briefs where people have written down the legal principles and in parentheticals just laid out the principle and not actually gone back and read the facts of the case. And the facts are actually bad for us. They went the other way. It just happened to have a helpful statement of the law. That's not helpful. That's actually going to be probably with an effective advocate on the other side, slammed back in your face, and it's going to be end up hurting you no matter how helpful the legal principle was. So remember the facts, and if the facts are good and they're compelling, talk about the facts of the case, not just the legal principles that are set forth in them. And then the last point I'd make is take ownership and take pride in your writing. Obviously, you've all joined this panel on a 7 p.m. On a weeknight, and so you're all people who do take pride, and that's great. And because that's how I think your writing will be better. It's taking pride in what you've written and making it better, and having fun with it, because there's very few things I think in this profession that is as gratifying as sort of working hard with a team on a written work product that you can just see is getting better over time and through work. And and when you're proud of the final work product, and that it's something that you worked on with others, that's a big part of the joy of the legal profession, advocacy writing. So enjoy it.
Thank you, Joon. I'm just going to make 6 points, and again, I have the same problem as Joon, only worse, which is everyone said everything, and it's hard for me to add anything. So to some extent, there are different ways to phrase the same points. Concision. You have to remember that a lot of times the people you're writing for have limited bandwidth. They're senior people. They don't have time to read very long memos. And so concision really is one of the most important aspects for a junior person, particularly. I remember when I clerked, my first judge required all bench memos to be 1 paragraph long, right? And then the idea was you'd have 1 paragraph on the bench memo, and then he'd have a conversation about the case. And the conversation would last an hour or so, perhaps, depending on the case. But the bench memo had to be a paragraph long. And then my second judge, the bench memos had to be 2 pages long. I mean, the cases were much more complicated, but he had a two-page rule. And if it was a really complicated case, appeal and have a 3-page bench memo. And I realized how hard it was to write a bench memo that was that concise. I mean, it was, you had to take 20, 30 drafts. You'd start out with 15 pages, and you could actually boil it down to 2 pages. It just takes a lot of effort. And you have to realize that basically the people you're working for, the people who you will be presenting to many instances, they're going to have limited time. And so concision is valuable, not just in terms of boiling down your argument, but in terms of giving your product in a way that other people will read. When I worked in government at the Pentagon, there was something called the bottom line up front. So every memo had to have like a quick statement of what the memo was about at the very beginning, so that the senior officials can actually just read that statement and figure out what the thing was about and keep reading if they wanted to. And so keep that in mind. Second, things that junior people in litigation teams can impress senior people with. One is really getting a case, because oftentimes the baby associate or the junior person is the one who's going to really have the initial case research assignment and finding decisions one way or the other. And always make it a point as a senior lawyer to read. I mean, you can't possibly read all of them, but I do try to read several of the cases, and it always impresses me when I see that an associate has really done a good job of, Joon mentioned this, not just taking out language, but kind of understanding the facts and how the case breaks your way or the other guy's way. And then, when it breaks the other guy's way, making clear that that's what's happening, and putting that on your list too, so that basically as the brief gets drafted or the opinion gets drafted, we can deal with those issues. Another thing that junior lawyers can do to impress senior lawyers is just an attention to detail, right? With the proofreading, the junior lawyer who picks out even simple grammatical mistakes like misquotations, like citations where you get the language wrong from the initial, which indicates that that person actually looked up the original case and figured out that there was another Supreme Court, an internal citation that was garbled, right? That always impresses the heck out of me when you see a correction and you say, hold on a second. How did that person find that? They've actually looked up the original case and fixed a garbled citation. So that's actually, attention to details is a good thing to do. Third point, in Judge Chin's materials, I think one of the authors used the term romancing the verb. I think there's a problem that a lot of young lawyers have, and I call it romancing the memo. They don't understand that you're working on a deliverable. You have a timeline. You can't spend, it's not like a term paper where you could spend forever researching the thing. I mean, it has to be delivered. It has to be usable. Don't romance the memo, right? Make sure that you produce something that's usable at a timely fashion. If you have a deadline, meet the deadline, right? No matter how good your research is, if it isn't delivered on time in a way that can be put in as an input into the process, it's not going to be useful. Fourth point, it's a good, so another experience from clerking. My first judge that I clerked for, he was just remarkable in terms of his ability to identify within 30 seconds of a conversation with you exactly those matters that you didn't really understand very well, right? And when you have a case, there's always some facts, some case you don't quite understand, and you glosses over it. It was remarkable. I mean, he had an ability to identify very quickly intellectual laziness and just ping away at it and continue to ask questions. And I remember I was humiliated the first time because there was an extensive record. I'd looked everything up. It was a complicated utility case, and I really didn't understand one aspect of the case. And within 30 seconds, he was asking me, well, what about that? And I had thought, it's not that important. I'm not going to sit down and feel what's going on. And you can make damn sure that after that, I made sure to understand everything. And when you come to those roadblocks or you feel like, well, I don't quite get it, but I don't think it's important, and it's going to take me too much effort to figure out what the heck is going on, that's exactly when you pause and you really roll up your sleeves when you try to figure that out, right? And these are lifetime habits that you'll develop, and it's important to sort of get the habits down early in your career. Similar to that, proofreading your own emails. I mean, I think all of us, I mean, I don't do it as much as I should anymore because I'm sending so much stuff out, and I'm a law professor, so I'm constantly sending emails out, but just basically careful about how you present and essentially checking your work, particularly in your written product. I mean, those are the habits that you're going to form now that will stay with you for a very long time. And finally, I see a few of my students out there, but oftentimes as lawyers, we have clients, and our written product is for the client. So it's very important to be able to explain even the most complicated concepts and legal ideas and analysis in plain English terms that a fairly educated non-lawyer can understand. And I'm going to put in the chat a memo that I helped to produce at the Department of Defense for a major policy. It's a 2-page memo, but the legal analysis that goes into it, it's the memo where Secretary Esper effectively banned the Confederate flag on DoD facilities. But the legal analysis that went into this 2-page document consumed thousands of person hours and intricate analysis into First Amendment issues, religious freedom issues. At the end of the day, the deliverable was a product that had to be intelligible to people who were not lawyers. And so I think that's an important thing to remember as we go into legal writing. So I think that concludes the presentation part. We have about 20 minutes. So I don't know if I don't see any questions in the queue, but you could send them over to me in chat, and you could direct them particularly to anyone on the panel. If you don't want to direct to a specific person on the panel, I'll take the question and then give it to somebody. But you can send in chat or by raising your virtual hand. There really should be some questions, right? And if you feel like you want to ask one of our distinguished panel members something that isn't explicitly to do with legal writing, that's fine too.
Can I ask Joon if you can talk maybe a little bit about the small investigation you did recently without, divulging any secrets, but just, was it fun?
That was the one subject I was afraid someone was going to ask. It was interesting. That, and as like many things we do, the end work product was going to be a written work product. So, some of the things that we've been talking about were things that we considered, and thinking about making something readable and accessible is something that I think it's it's on point. And so and I had my Strunk White here for it.
It must have been fun and exciting, I would think.
We have more than 50 attendees. I mean, certainly some of you must have questions, please. Yeah, Flavian, and then Kevin.
Yes, I have a question, but I'm not even sure there's an answer to that. We discussed what we do in law school and legal clinics and internships. Is there any other way to practice legal writing on our own, like at home? Or I don't know, is there any way to practice alone?
So since I brought that up, I'll give you an answer, but it's not directly the answer that I think you are asking for, but I think it's a suggestion. So I don't know what examples you can have at home where you just sort of write something, but what you should do is look at what other people have written, right? So you can go on Westlaw, LexisNexis, and look at briefs that have been submitted. And I think that's a really good way to sort of understand how legal writing goes and what works and what doesn't. And if, there's a case that you're interested in or that you've heard about, and, it's and that you can get a sense that those are, important issues that were discussed and well briefed, and it was a high profile case, that would be a good way to sort of, at home, even if you don't have a direct assignment from a clinic or, something that you're doing in school, it would be a great way to kind of get an example of what good legal writing is.
Yeah, I would add that we say good legal writing, we really are talking about good writing. There certainly are some differences, of course, but good writing is good writing, and write as much as you can, and just get into good habits. Write more. If you're still in school, take some courses where you have a chance to write, and you're not just answering true false questions. And put yourself in situations where you're able to write. One important thing, Professor Lee alluded to it, but emails. And we're in this. We have a generation used to texting, and when you are writing an email in these contexts, you want to do a good job with it. I mean, you don't want to give a bad impression because you've written an email that has typos in it. I'm guilty myself. You're doing it quickly and you make a mistake, you don't catch it, or a common thing with texting is you fix it in the second text, but you need to give thought to these things and to try to make a good impression.
Kevin, I see that you have a question, right? And then I'm going to go to the chat queue.
Well, first of all, thanks for doing the panel. We really appreciate it. My question kind of refers to the audience of a paper, that is. It sounds like there's a lot of kind of blanket advice that's out there, especially the stuff that you guys have given. If you're writing a memo for a client compared to, say, a judge or, a senior partner or something, are there major differences between the structure and kind of what you're including into those papers, or are they pretty much the same in the sense that you want everything to be clear and you want to like explicitly lay out the legal kind of sides?
Do you want to take a first stab at answering that question? Yeah.
Yeah, I mean, just to sort of follow up on what Judge Chin said about, some of the advice and thoughts on writing and what is legal writing? Yeah, you can practice those in emails, as you said, and I think the advice is the same in the sense that you need to know your audience, right? So obviously, a brief to the Second Circuit is not going to look like an email to your client that you need to get out immediately, because the decisions come out and they should know about it, and you want them to hear about it first from you. But the advice is the same in the sense that you need to know who your audience is and why you're sending this. And always, one of the purposes will be to convey your thoughts clearly and as concisely as possible. The advice of being concise, that is 100 times, whatever we were saying about judges, and courts and brief for the clients in emails, it has to be even more concise. I mean, you need to really get to the point quickly. And not just clients, even internally, and make clear why you're sending this email. Get the points you want to convey, and what do they need to do with it? Is there something they need to do with it? It's sort of the same thing, right? If you think about it in a brief, you're saying, why are you writing this? Because you're a litigant. You want to convey your argument, convey your right, and you want the judge to rule for you. And those are the things that need to be in your mind when you're writing. When you're writing to a client or internally, you say, I need to convey this information. I need to convey quickly in a way that they can read it and understand it in literally 30 seconds or a minute or less. And they need to know what to do with it. And so, even taking those everyday communications as an opportunity to write clearly and convey your thoughts clearly, people will notice, and it is actually a skill that not everyone's good at, and you get better with practice. And so I think sort of that's a long-winded way. I wasn't very concise of saying, yes, the advice is the same, but the product will look different.
Yeah.
I think there's also a difference in that, with a client, you're not trying to persuade in the same way. I mean, there may be some persuasion involved. You're trying to persuade the client to do the smart thing or the right thing, but it's more of a predictive type writing. Whereas with a court, it doesn't really matter whether you're right or wrong. I mean, hopefully you're right, but even if you're wrong, as long as you're not making a frivolous argument, you know, it's still fine for you to try to persuade. And so I think in that sense, you will approach the two types of writing differently.
Now, and I mean, and I don't know, Sapna, if you and Joon could also confirm this, but I mean, to some extent, when I was working in government, so much of sort of the spot analysis is done by emails. And the reality is, you know, there are the deliverables where you have a memo. But I think that, you know, when Joon and I were like young in law school, I mean, so you had this format, and this goes to a question that was in the chat of IRAC format. And, you know, it's like, what's the issue? What's the finding? And you sort of had this cookie cutter memo, right? And that just doesn't happen very much anymore. It still happens where you give clients like some kind of baseline analysis, like let's say a client is wants to do trade with North Korea, and you want to give them a sense of the sanctions environment and how to get licenses or something like that, right? I mean, there are still occasions when you do this, but a lot of times the advising, the issues that come up, I mean, you sort of do it through emails, and it really is an art form, the person who can really boil down and have an effective email. And so I think that sort of making it a habit in your own personal life is a good way to train yourself to use that in your professional life.
Yeah, I agree, because I think even though your vehicle might be an email to get your thought across, and, you know, we tend to do that much more now, whether it is with clients, you know, you're not always writing like a formal memo that you're sending over to the client. Opposing counsel, you're not necessarily always, you know, putting things in a, you know, letter format. You're writing to them by email, and that happens, you know, much more often than it used to before. But even in that, you have to treat it as a piece of writing that needs to achieve the purpose that it's meant for. And you need to spend the time that you need to in order to edit it. You know, I print out my email that I'm writing and I'll edit it, right? Just like I'm editing any other piece of work. So the same sort of tips and advice that we've given you in terms of, you know, be concise, be precise, who's the audience. I always find that, you know, when you're writing to your client is always also very busy. You know, they don't want to get to the end of the email to be able to understand, you know, what the point of your email is. Just like judges, you know, don't want to get to the end of the brief in order to understand what it is that you're trying to argue. Just as you do an introduction or a summary of an argument for a brief, it's very helpful, especially if you're writing something, you know, you're making several points, you're trying to give the client sort of the overview, put that up front, right? Put a paragraph up front and then explain. And that, you know, again, takes the same types of skills where you have to sort of understand what it is that you want to achieve, where are you going with this, and you're forced to sort of summarize your thoughts up front. And you should do that because the audience at the other end most often, you know, doesn't have time and wants to sort of get the high level analysis, you know, what is the answer that you have for me? And then I'll read the reasoning that goes on behind it.
Yeah, I mean,
So
the text in here, the question here says, is, you know, IRAC, issue, rule, application, conclusion, still a useful framework? I mean, it's been a long time since I've looked at it that way, but looking at it, it is. I mean, you can, without writing, you're not going to write an email to a client that says IRAC, you know, issue, blah, blah, blah. They'll stop reading and probably stop calling you. But you can imagine an effective email saying, dear so-and-so, here's this issue that's come up. Generally, the law, you know, the law says this, applying that to here, I think blah, 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 conclusion. So I think we should do this. Let's talk. And that's a pretty clear and organized way of conveying your thoughts, which is, you know, what's the issue? Why am I writing you? And here I've done some thought, and here's what I think we should do.
So we have one question about additions, and I don't know if somebody on the panel can send the answer to that. It seems to be something that we can handle written. But we got another question, and I think, Judge, you're the best one to handle this. I've seen some comments that I find crossing the line to insulting regarding the opposing party in motions. I usually ignore them and stick with legal arguments, but sometimes I feel like the unprofessional sentence needs to be pointed out. It's just best to ignore those comments. And I think this is a good question about like how nasty to be the other side. I mean, sometimes in the briefing, you know, you sort of get, I wouldn't call it ad hominem, but you get really nasty, right? And I think that the sense of the comment is correct. That could backfire, but is there a way to do it in a diplomatic way that's effective, right?
Yeah, I mean, judges don't like these ad hominem attacks. Judges don't like it when the lawyers, you know, get into the street fighting. I remember as a lawyer feeling aggrieved and complaining and, you know, getting no satisfaction at all. So I think you do want to rise above it. If it is somehow impacting the argument, you can try to use it to your advantage. You know, quote back the offending sentence and then come back with a strong rejoinder. And by strong rejoinder, I do not mean shouting or coming back and calling the person names as well, but coming back with a strong logical response that just, you know, cuts the legs off of what the person was saying. But the sentiment is correct. We don't like it when lawyers do these things.
You know, one effective technique I found is find when they really garble a case and sort of like be very polite, but show how they really garbled the case, right?
Yeah.
That's kind of you know, my opponent, my worthy opponent says that this case stands for this. Well, let me tell you a little bit about the facts of that case and the fact that they've taken that one sentence completely out of context and essentially the case actually stands for the opposite proposition, right? That's a good way to do it.
Yeah, I mean, pointing out that something has been taken out of context is good. I mean, that's strong, and you can do that, you know, in a somewhat diplomatic but effective way. But yeah, it's not good when lawyers cut off the second half of a sentence, for example, so that it reads the way they want. That's a bad thing, and that does cost credibility. And you know, I should just. What does it mean when you lose credibility? It's hard to really make that concrete. I think what it does is, if you say something that's not credible, if you say something and you're a jerk, what may happen is we just won't think as hard about it. You know, if a lawyer I respect, I know, says something, even if I don't agree, I'm going to think hard about it. But if you're a jerk and you've lost your credibility because you're making outlandish arguments, I'm just gonna we are human, you know, it's human nature, and you don't spend as much time thinking about it.
So Maximilian, I see you've had your hand up. So please unmute yourself and ask your question. Yeah.
Oh, well, first of all, thanks again for this very interesting panel, which is of great help, especially for international students. I was wanting to react to your advice that a writer should know his own audience to be the most effective, and wanted to ask if you had specific advice or tips for effective legal writing in an international context, as opposed to an entirely US context, for example, in an international arbitration or international litigation.
Yeah, I think Joon would be, I know you've been involved in some of this. I mean, so do you want to take the first stab at that? Yeah.
It's a very good question, and it's difficult because particularly in international arbitration, there's a bit of a club, and there's a way of doing things, just kind of the way there is a way of doing things in domestic litigation. And to me, knowing the audience and being yourself, the two things can collide a bit. I do think understanding the way things are presented and following kind of the norms that the reader, for example, in a national arbitration tribunal would expect is important. But also you have to be genuine, right? And if, I, an American lawyer, start adding OUs and spelling things the British way to appear like an international arbitrator, that sort of is fake. And I think being genuine in yourself is more important. I actually found, this is not written advocacy, there was an international arbitration where, I was doing a cross-examination, and sort of only one way American lawyers know how to do cross-examination. And it can be a little bit considered a little bit rude in the way you question and ask for yes or no answers. But I actually am someone who believes that's actually the most effective way to cross-examine people, and it worked. And or at least I thought it worked. But and so I think it's important to, yes, know your audience, but be yourself. So if you are from a different jurisdiction than America, and don't try to be an American, a cross-examiner or a writer, but I think understanding your audience, but being yourself without offending people or norms, I think is the balance I think you need to strike.
So we have 2 more questions and 2 minutes. So if you could, Junsung and Tyler, if you could ask your questions, and then I'll pose them out to the panel, right? Junsung and Tyler.
Oh, do you want us to speak, or?
Yeah. So Junsung, why don't you go first? Ask your question, and then Tyler, ask your question, and then we'll hear from the panel.
Okay. Our writing professor told us that every firm or partner and every judge will have a writing style they prefer, even down to citations sometimes. When do you expect your junior associates or clerks to get used to your style?
Tyler, do you want to ask your question?
Sure. So I think we've heard that being concise is sort of the name of the game. However, I guess this could sort of share a border with being curt. And so would you prefer that someone comes across sort of cold in their writing while being concise, or would you rather have them interject sort of a little bit of warmth or persona in their writing? I mean, how do you feel about writing that is so concise that it sort of borders on sharp?
Right. So I'm going to answer Tyler's, and then I'm going to throw Junsung's to the panel. I mean, you should not be curt, right? I mean, there's a difference between concise and sort of like dismissive, or curt to the point of being rude. I mean, being a lawyer is a service industry. The best lawyers understand that you're an advisor, right? And to some extent, you should not sort of, there's a way to be concise and yet not curt. And I think that that's what we should aspire to, because the tone is important, particularly if it's a client communication. With regards to Junsung's, like different senior lawyers, different judges have styles and so forth. Like how does somebody who's going to a firm or going to clerkship, how do you pick up that? And is there advice you might have? And all 3 of you, Sapna, we haven't heard from you in a bit. Like, so you could sound off first, and then the judge and Joon.
Sure. Yeah. I think you coming in as a young associate, your primary job is to follow the things that we've talked about, which is be concise, be clear, make your arguments in a persuasive way, present the facts in a proper way. Beyond that, you're going to end up working with a certain team of people, right? And with particular partners. Sometimes you may, sometimes you may not. And there will be instances where people want things done in a certain way, and you'll adjust your style based on that, or they'll edit your work in a different way and, fix that according to how they want it to look, or sort of the tone they want it to take. But I think, when you're coming in new, you just have to do the things that you need to do in order to make your writing good, right? And you're going to learn along the way. You'll learn about how different people write and how they want it presented, and you might incorporate some of that. But the reality is you're going to be working with a variety of people, right? And what you need to focus on is keeping your basics correct.
Judge?
Yeah, there's a difference, obviously, between a law firm setting and clerking. As Sapna just said, at a law firm, you're working for a variety of people, and I don't know that you should be changing your style just because you're working for a different person, particularly when it's hard to find out what someone is looking for. And I think good basic writing, and you want to be true to yourself. When you're clerking or interning for a judge, you're working for one person. So it's easier to learn whether that person has a preference in terms of style. You can obviously read prior opinions of the judge. In any job, it's really important to get precedents, find out how things are done. I don't want, with every law clerk coming in, changing the formatting, changing the font, changing how we do a caption. And at a law firm, there may be preferences on how captions are done, the signature block, these kinds of things. And those kinds of things are not hard to figure out. You get some samples of prior works, and you apply them. My final thought is, do not get into a frame of mind where you are submitting something that you think is a draft and it's going to get better as you get editing. You should try really hard to submit the best work that you can do. In your mind, it should be absolutely final, as strong a piece of writing as you can make it. And it will be edited and you'll be asked to do more. But don't get into the habit of putting in something that's half the job because of your thinking that, well, I'll get some feedback and then we'll make it better. I'll stop there.
Joon, you have the last word.
Yeah, I join in everything people said. I mean, I think when people say you should find out what style the partner or the judge likes things in, I mean, I think they're talking about kind of the procedural things, like what's this formatting style, when do they want it, what type of, do they really, generally speaking, maybe they'll just write the preliminary statement themselves. I don't think anyone's saying, that lawyer prefers a lot of passive voice and lack of clarity and disorganized briefs, right? So the general advice of organization, logic, clarity, active voice, that's just better writing. And, frankly, if someone's telling you that's not what they want, then, when you become partner, you'll start writing better.
Well, thank you very much to our panelists, Judge, Joon, Sapna. Session's being recorded, and I hope that all of you found it as rewarding and rich in exchanges as I did myself. I picked up a lot of great lessons. Thank you for giving us your time on this Tuesday evening. Take care.
Thank you.
Good job. Good job moderating, Professor Lee.
Yes,
Thanks.
thank you.
Have a good night.
Night.